Welcome to the latest episode of Risk Settlements Podcast, Alternative Litigation Strategies, where I interview key leaders in the commercial litigation arena, and we discuss novel litigation and settlement strategies for complex commercial and class action litigation. I'm your host, Kevin Skrzowski, with the litigation consulting firm Risk Settlements. And today we'll be discussing some very interesting developments in local and state biometric privacy laws. I'm pleased to welcome our guest, David Oberly, a business litigation attorney at the law firm Blank Rome. David specializes in counseling and representing clients in a wide array of biometric privacy and data security matters, and is also a prolific author and thought leader in this expanding area of litigation. Good morning, David, and thank you for joining.
Morning.
David, tell us a little bit about your career at Blank Rome and how you got into biometric privacy.
Getting into biometric privacy is just a natural extension of my then privacy practice. At the time that BIPA was becoming big, around 2018-19, CCPA was our big focus. And then the Rosenbach opinion by Illinois Supreme Court came down, which said that plaintiffs don't have to allege, let alone establish any actual harm or injury to proceed with a BIPA claim, which just opened the floodgates to class action litigation. And it was at that point where I recognized there would be a big need for services in this space from our clients and potential clients. So that's when I started getting into it. And then as BIPA just continued to grow in terms of class action litigation, and then the other more municipal laws that have been enacted recently, it's just increased the breadth and scope of our practice and becoming a big thing. And it's only going to get bigger moving forward.
And I want to ask you a lot of questions today about the articles that you've written, and you've written a ton. How do you find the time to write so prodigiously?
Well, I have a business background. My major as an undergrad was finance. I kind of grew up in a business-oriented household. Both parents worked in the corporate world. And I've always really been interested in the business side of law and understand there's two aspects to practicing law that are necessary to be a top attorney. One's the lawyering part. The other part's the marketing and business development part. And so I, at a young age, knew that I had to market myself and to generate new clients and have a successful career. And article writing was the first place that was easy for me to just jump off and start marketing myself immediately, and just kept doing that over time. And the other benefit of writing articles is that you learn so much from the writing, more so the research process. And so that's something I've just continued to make a priority in my practice, on par with billing hours.
Right. And, I think that marriage of law and business is so key. And I think it's something that many lawyers don't do. And so many are trying to do a better job. But it's a great way to actually not just understand the law, but also know your clients and be able to counsel them to the best of your abilities. So at the end of the summer, you wrote an article on BIPA's newest class action trend, which was targeting the use of voice-powered technology, pointing out that in 2020, class action lawsuits filed under BIPA focused on the use of fingerprint biometrics, mainly for time and attendance. But in 2021, we've seen a much broader range of biometric technologies being targeted for litigation. First, there was a wave of facial recognition, but most recently, it was around voice-powered technology. What is a voice biometric?
There's a big distinction here. A voice biometric is voice data that is used specifically for the purpose of identifying or verifying an individual. So if it's used for that purpose, it falls under the scope of BIPA. If it is just a voice recording that's not used for that purpose, then it doesn't fall under the scope of the law, and it's not considered a biometric identifier or biometric data. Those terms are used interchangeably. Also, you mentioned voice-powered applications and programs. They're also recognizing your voice, but they're not using your voice to identify you or verify your identity. That's a big distinction there, and it's a distinction that is pretty clear under some of the case law, BIPA case law, but at the same time, there's still plaintiffs' lawyers that are trying to push the envelope there with what the definition is. So that's why we're seeing the wave of class actions this year.
Okay, so are you saying there's one that actually captures identifying data that violates BIPA, not just recognizing the voice, so it actually can respond to commands? Is that the distinction?
Yeah. So the voice print actually takes your voice data and converts it into a distinctive pattern of curved lines and whirls is how it's been defined by one court under BIPA. And then it's used to match your voice with something that's in a database along the same lines as facial recognition or a fingerprint. So it's akin to a fingerprint, but with your voice.
So fascinating. So, how do you advise companies that are capturing voice data or a voice print to help them try to avoid litigation?
The first step, obviously, is to figure out if that data falls under the definition of voice print. If it does, then obviously you have to adhere to BIPA and all the other biometric privacy laws strictly. If not, that becomes, if not, when I say that, I mean, if it's just a voice data that's not a voice print, the question is a little trickier to answer. We recommend that companies do try to comply with BIPA, not strictly, but where it's feasible and not cost prohibited, especially the privacy policy notice and consent aspects. But in doing so, there's a fine line you have to kind of straddle to make sure that the company clearly states that what they're doing is not voice biometrics and it does not fall under the scope of the law. So it's a real gray area because companies want to make sure they deter the potential of BIPA lawsuits, but at the same time, they also want to make sure that plaintiffs' lawyers that are looking to file a suit, if they come across your company, that you've got some compliance steps there that will deter the likelihood of a suit from that point of view as well.
Okay, so where would a company state what their technology does and doesn't do? Would that be something that they would want to put on their public facing web pages?
Correct. So one of the main requirements of BIPA is a publicly available privacy policy. And in addition to having to set retention schedules and guidelines for the destruction of data, you also simply have to state that you're using biometrics. So you take this opportunity to say, we collect voice data. It is not voice biometric. It's not used for identification or verification purposes. And then if we do decide to change our voice collection practices, uses, we'll make sure to update this privacy policy and give you notice of that. So you're clearly stating that what you're doing is not voice biometrics, but you're still complying with the law. So you're covering yourself. When I say yourself, the company on both ends.
Right. And then the goal is, as you mentioned earlier, that would operate as a tool to disincentivize enterprising plaintiffs' attorneys from targeting that company and perhaps going after a more vulnerable target, I would assume.
Correct. And then another thing companies can do is to make sure they have a strong arbitration agreement and class action waiver. This is another deterrent to class action lawsuits because a lot of plaintiffs' attorneys are looking for their big payday. They call it their Facebook payday. Facebook BIPA case settled for $650 million. And that's what a lot of these attorneys are just going for the home run. So if they see these things that look like it may be a tough road for them to get a big settlement, they'll oftentimes look elsewhere for their big payday.
That's great guidance and advice. So, going back to the first wave of new BIPA litigation in 2021 surrounding facial recognition technology, I know that New York City started the year by enacting a new law regulating the use of these biometrics. What is facial recognition technology?
Facial recognition is the measurement of different parts of your face, which they call facial geometry, which is then compared to the measurements that are stored in a database, again, to either identify someone or to verify their identity.
That's really incredible. Now, tell us about the New York law and what are some of the problems that it was enacted to fix, specifically as it pertains to commercial establishments.
To clarify, the law applies to all different types of biometric data, but it's clear that facial recognition was the target of legislators. I think it was even singled out in the text of the law. leading up to when this law was passed, there have been several big stories that come out. Consumers and customers shopping at convenience stores, that kind of thing, who are being watched with facial surveillance for security purposes, but had no idea that it was going on. This law was in direct response to that problem.
I think I recall actually reading some articles about there were some inaccuracies with the technology that led to some bias and some wrongful arrests. Is that an example?
That's a separate issue, but that's also an issue that remains a big problem, but it was a major problem back then. It was probably another motivating factor in terms of enacting this commercial establishments law. There have been some accuracy and bias issues that have been identified, and I know that the facial recognition tech companies are addressing those, but there's still problems, and that's definitely something that legislators had in mind when this law was enacted.
Yeah, I can see that. That definitely makes a lot of sense. So, what are the penalties if you violate this law?
There's a private right of action, which is becoming a trend in new biometric privacy laws. To give a little overview of the law, there's two main components. First is a notice component. If you use biometrics, you have to place prominent signage at all customer entry areas. And then there's also a strict ban on selling or otherwise profiting from biometric data. The law provides that private right of action that gives $500 for violations of the notice provision and $5,000 for intentional or reckless violations of the ban on the sale or profiting of data.
So those are pretty hefty statutory damages. Have we seen much litigation, or have we seen much class action litigation, I should ask, filed to date?
Not to date. The law went into effect, I believe, on July 9th. So it's only been active for a couple of months, but it's only a matter of time before we do see class actions start to pop up with this specific ordinance.
So like a lot of things regarding these types of laws, it has yet to be seen, but there's a lot coming down the pike. Now, on the heels of the nation's first municipal level biometric privacy law regulating commercial establishments, New York enacted another biometric privacy law, the Tenant Data Privacy Act. Now, what does this law regulate?
This law regulates the use of all forms of biometric data by owners and operators of smart access buildings in New York City. And a smart access building is defined as any type of residence that is rented by three or more individuals or families, and a smart access system, which is used by landlords, is defined as a system that grants entry using biometric data or several other different types of data. What this ordinance really targets is the use of these smart access systems for entry to common areas and also into individual units in multiple dwelling residences.
Now, does this ordinance also allow for a private right of action?
It does.
So what should landlords in the Big Apple be doing to make sure that they are in compliance?
Well, luckily, landlords that are currently using smart access systems have until the start of 2023 to come into compliance. So they should use this grace period to fully come into compliance with the TDPA before it comes online. And in terms of compliance obligations, those include data collection limitations, having to get express consent from residents before using their biometrics, establishing privacy policies to give information to residents on the use of biometrics, a prohibition on using biometric data for any other purposes other than access, and also the requirement to implement security measures to make sure that biometric data is secured and safeguarded. So landlords will need to implement a privacy program that satisfies these requirements before the start of 2023.
That certainly sounds like a hefty dose of compliance counseling that's needed.
It is. It's a lot more than the commercial establishments law. So the restaurants have it easy compared to the landlords, at least at this point in New York City.
Wow. Now we've seen, going back to facial recognition, I mean, we've seen other cities that have also passed laws prohibiting the use of biometrics, including facial biometrics. Going back to another article that you wrote earlier this year on Baltimore's biometric privacy law, you had called that one the most draconian ban yet. How does Baltimore's law work?
It operates pretty much as it sounds like. It's a facial recognition blanket ban that extends to the private sector. So all individuals and companies, they cannot use, access, do anything with any type of facial recognition software, nor can they use any of the data that comes from any facial recognition software. So it's across the board, can't use facial recognition within city limits.
So just omnibus citywide ban, no exceptions.
There's one very, very narrow exception for access control to electronic devices. So if you use your iPhone, if you use Face ID to unlock your iPhone, that's the one narrow exception to the law. Other than that, it's a no-go with facial recognition in Baltimore.
So are there civil and criminal penalties attached to it?
This is what makes it draconian. So to give you some broader context, Oregon passed the first private sector facial recognition ban in September of last year. It went into effect at the start of the year, but it does not provide for any criminal penalties. This law does provide for criminal penalties where you can get up to 12 months in jail for a violation of this law, in addition to $1,000 in civil penalties for each day that the law is violated. So this is some big time penalty.
That's pretty intense. Has anybody been charged criminally under the bill yet?
No, they have not, but it's not likely that anybody will be charged criminally, but it's certainly possible. I compare this to the recent criminal indictment of Uber's former CLO, who is charged criminally for a couple of major missteps in the wake of a data breach. So if there's an especially egregious violation of the law and Baltimore wants to make an example out of somebody and get accountability for using facial recognition, this might be the avenue that they would take to do that.
It's plausible. It could very well happen. So, I mean, why are we seeing the trend with cities like New York and Baltimore taking matters into their own hands and enacting all of these biometric privacy laws and regulations?
It pretty much has to do with states and especially the federal government kind of sitting on their hands and not doing anything. In the absence of any additional regulation, cities are taking matters into their own hands and enacting their own laws, especially as potential issues for security and privacy relating to biometric data become more well known. So we had Illinois BIPA was originally enacted in 2008. It didn't really become an active law until 17 or 18, and then the floodgates opened in 19. There's also laws in Washington and Texas, but those only have administrative enforcement by the AG. There's no federal law of any kind. There's many bills that have been introduced, but nothing has been enacted. So in the absence of any other regulation, cities are saying we've got to do something, and this is why we're seeing these ordinances and laws at the municipal level.
And what do you see coming down the pike with other cities or specific industries like landlords? And what do you foresee will be the increasingly complex patchwork of laws that companies have to comply with?
You took the words out of my mouth. I was going to say that moving forward, we're going to see more laws in different parts of the country, especially states and cities. They're all going to have some common themes in terms of requirements such as privacy policies, destructing biometric data within a certain time frame, providing individuals with notice and getting their consent before collecting biometric data. But they're all going to have their unique nuances, and no two laws are going to be the same. So it's going to be extremely hard to comply with laws as they are enacted. So what we recommend is that companies put together and implement a biometric privacy program that integrates these common principles so that when new laws do come online, these companies only have to make slight adjustments to their programs instead of making wholesale changes or starting from scratch once a law goes into effect where they do business.
Right, but you're going to have to keep track of all of the state laws that are coming down the pike, all municipal laws for every business in every city in which that business has a branch office. Very complicated.
Correct. And then another thing is that even for companies that are under no biometric privacy regulation, it's a good idea to find an experienced biometric privacy attorney who can advise you and the company on which laws are in effect, which bills are being introduced, and which laws have a chance of going into effect, so companies can get ahead of the compliance curve and start their compliance actions before law is enacted, and they have to jump and scramble to get into compliance.
This sounds like quite a hot area of law for a young lawyer to get into if you definitely don't want a lack of business.
It's only going to become more active, and with all the new laws that are sure to come in effect in the next months and years.
Now, final end all be all question. Will we ever get regulation at the federal level? If so, when do you think? And then what impact will that have on all of these state and municipal laws that are being enacted?
This is one of my favorite questions because there's so much that goes into answering it. If you would have asked me a couple of years ago, I would have said that there wasn't really a high likelihood. Last year, Senator Sanders introduced the National Biometric Information Privacy Act. Don't quote me on the name, but it was a national version of BIPA. Obviously, it didn't get passed, but the momentum for a federal law is growing. There's two big things with consumer privacy laws and biometric privacy laws at the federal level that are major disputes between legislators that have kept a law from coming into effect until now. The first one is whether or not there should be a private right of action. Some legislators think there should be because that gives the law teeth. Others think that it could turn into a BIPA situation where companies are involved in bet-the company litigation for mere technical violations of the law. The second one is preemption, whether or not the federal law should just eliminate all the state laws. So legislators are getting closer in terms of coming to a consensus on those two issues. And at the same time, the other big factor is the additional municipal and state level laws that we see. If we see a bunch of different laws that have very differing requirements, then the federal government might step in and say, hey, we need to put a uniform law that applies to all 50 states to ease the compliance burden. If that's the case, we may see a kind of copycat of the TCPA where technical violations are turning into class action lawsuits in all 50 states. But it's yet to be seen whether or not we'll actually see a federal law, but its momentum's increasing.
There definitely is a ton of information that everybody, lawyers and businesses, need to monitor and track going forward. It's really a fascinating area. So I would imagine, David, what can we expect from you? Any upcoming articles or programming from you or your practice in this area, or any other hot areas of commercial litigation that we should look for?
Nothing special in terms of articles or anything. I will still regularly publish articles. Most of the time you can find them in Law 360 or Bloomberg. In terms of upcoming legal developments, I think everybody should monitor the start of 2022 to see what legislatures introduce new biometric privacy bills. Each year, more and more states introduce bills. Obviously, they haven't been successful, but 2022 might be the year where we see more of these state level biometric privacy statutes along the lines of BIPA. And New York in particular has introduced bills probably for the last 4 years. Each time it's gained more support, but I think they have a bill that's pending right now that will stay active in 2022. So that's the big one to look out for right now, because that's a copycat of BIPA, and it would just take everything that's going on in Illinois and add it to New York in terms of litigation.
It sounds like 2022 will be a very interesting year, and I think that's great advice. Well, David, that is about all the time we have for today. It was a pleasure having you as our guest. I want to thank you for your time and all the very interesting and valuable insights that you shared with me and with our audience today.
Thanks for having me.
Definitely. And I also would like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program, or would like to learn more about litigation and settlement risk transfer solutions that are available, including solutions to transfer the settlement risk in active biometric litigation, please visit the Risk Settlements website at www.risksettlements.com, or you can reach out to me directly at kevins@risksettlements.com. Thank you for listening.